Good morning, everyone. I'm Romina Cameron, a fully accredited family mediator and member of the Family Mediation Council since 2017. I've worked with clients from diverse cultural backgrounds, which has allowed me to connect with individuals in a meaningful way during our mediation sessions. Last year, I became a personal practice consultant, which has meant that I can mentor aspiring mediators to becoming fully accredited. I'm also the founder of ARC Mediation, a practice which is focused on family mediation services. I want to thank everybody for joining us today. It's an absolute pleasure to be chairing this discussion on the role of culture and religion in mediation. As a mediator myself, I know that understanding cultural and religious differences is key to fostering effective, respectful, and conflict resolution. In today's session, we'll explore how these factors influence the mediation practice and how they can both help challenge and also support the process. We aim to discuss the strategies that can also help us when we are involved in mediation. We have an excellent panel of experts here who will hopefully share their insights in just a moment, and I encourage an open and respectful conversation throughout. So without further delay, I have the pleasure of introducing Sara Al-Jurani, a bilingual family lawyer at Irwin Mitchell, specialising in Sharia family law and Islamic marriages, both internationally and in England and Wales. She also advises on Islamic divorce and nikah agreements, ensuring clients navigate both legal and cultural aspects. I also have the wonderful pleasure of introducing Devorah Greenberg, a trilingual family mediator with expertise in Jewish divorce, the GET process, which we will be hearing more about shortly. She works internationally, helping clients navigate both civil and religious legal issues with sensitivity to their cultural and personal needs. There will be a Q&A at the end, so please do pop your questions throughout and we will do our very best to answer them. I'm going to hand over to Devorah now. Thank you.
Thank you, Romina. I feel like I'm going to speak. It's like listening to a podcast on 1.25. I'm going to whiz through my slides so that we don't take up too much time. During this part, we really want to have an open discussion and encourage as many questions as you can. Okay, so Romina, do you want to take us to the first slide? And we're looking right now at just considerations for Jewish families, be they very religious or on any part of the spectrum. Go ahead, click again. So what is the GET? The GET, which is a term used for both the process that people might be going through and also the actual document, is a document which is written by a scribe and handed by the husband and received by the wife. It usually, but not always, it doesn't have to, but it usually takes place in a Jewish court of law in front of two witnesses. During the process, the role of the judges is only to facilitate the GET. They don't issue the divorce, they don't proclaim it. It's not theirs to proclaim, they simply facilitate the process. I've just added here, it is needed, the GET is needed if your clients are going to want to remarry within the Jewish system. Next slide, please. Oh, wait, go back a bit, sorry. Just to say, on the left there, you can just see a little snippet of a GET document, and that's what it looks like. It's written in Aramaic and it's signed by the witnesses. Okay, good. Just wanted to mention that. There are some really key features, essential features to the GET. I've written here volition, the document itself, which you just had a window into, the witnesses, who they can be and who they cannot be, the intent of the participants, of the people giving the GET, or the person giving the GET, the person receiving it, and also the way it's delivered, how it can be delivered. And these are discussed in a tractate of the Talmud called Gittin. I've focused on just the feature of the GET, which is its voluntary nature. And I think it's very kind of interesting for the mediation community. We know that in the last year or so, there's been quite heavy and heated debates as to whether we could extract the voluntary nature of mediation and simply make it that the court renders mediation compulsory. I know I've witnessed quite heated debates about whether this would really ruin mediation or take away its essential quality if it was no longer voluntary. Clients would feel compelled, clients would be there, but not of their own volition, and that would really mar and compromise the quality of the decisions they make and their discussions. In a similar way, if the get is not voluntarily given and voluntarily received, it is no longer a valid get. It loses its essential feature. It loses its validity as the document that it's meant to be. So that's the one feature I thought worth mentioning to a group of mediators who perhaps can understand that idea. Okay, next slide. Thanks, Romina. There are, as I mentioned before, there is a spectrum of religious observance. You've got people who feel kind of culturally Jewish, they relate to it a bit, but they're not that observant of the halakha, the law. And you've got a range of liberal, reform, Masorti, and Orthodox Jews. The reason I mention this is for a couple of reasons, but the one that I'm going to focus on here is that you can get a get in an Orthodox court of law, you can get a get in a Masorti, a reform, but what you can only do is get a get that you want to be accepted in the future. The Orthodox get is going to be the only one that's accepted across the panoply of different types of Judaism. And that is useful for your client because if they want to remarry, they don't know if they're going to remarry when they're meeting you, and they don't know who they're going to remarry, but they might remarry someone who cares about getting married in a more traditional way, in an Orthodox synagogue. And I actually, when I was working at the London Beth Din, had clients who rung me 20 years after they'd got divorced, and now they'd met someone who was a bit more Orthodox and who wanted to get married in an Orthodox way, but they couldn't because they didn't have an Orthodox get. So the Orthodox get is accepted by all of the groups in Judaism. I've just popped here, no get is needed if your client is married to a non-Jew. So if it's a Jewish person married to a non-Jew, you don't really need to go into it at all with them. Thanks, Romina. Next slide. I'm going to just whiz you through very quickly the logistics involved. So who can apply? Anyone can apply. The husband or the wife can apply for the get, and they can apply at any time. Actually, I should say also they can apply together. It sort of doesn't matter to the based into the Jewish Court of Law. They can apply as soon as they've decided to divorce. The actual get can only take place once they're living in separate spaces. They don't have to have been living in those certain separate spaces for any amount of time, but you know, even if they've just moved out, they've lived out of the same house for a week, they can then actually do the get appointment itself. Interestingly, there are no grounds for divorce in Judaism. It's a no-fault divorce. And when I have seen the Dayanim, the Jewish court judges, facilitating the gets, they're at quite pains to explain that they're not there to assess why the marriage broke down. There's no focus on that. They really are there just to help clients move forward to the next step in their lives. It might be helpful for mediators to know what their client would be going through, because hopefully you will be able to guide them to an Orthodox based in or a court of law, and they will have an initial meeting. That's a quick meeting where they go in and they meet the judges, the Dayanim. The main purpose of that is A, pastoral, and B, to really define the names that are going to go on the get document. The next meeting is a bit more of a chunky meeting. You might want to explain to your client it'll take half a day. And that is where the husband instructs the scribe to write the document. And then there's that takes about half an hour. Then there's a break where the scribe then literally writes the document on the parchment. And the third part is the handing over of the get. And that is where the husband hands it either to the wife or to an intermediary, and she receives that get. And that really is the moment of affecting the end of the marriage. I mentioned an intermediary. You may have some clients who really don't want to be in the same room together. It's going to be too painful, there's too much conflict, or they just think it's going to be a bit too intense. In that situation, they can hand it to an intermediary person, and that person will hand it to the wife at a future date, at a later date. we recommend that that happens very quickly. So I used to find the get ceremony would happen on one day and the wife might come in later or the next day to the Basin, to the court of law to receive her get. After they have finished that ceremony, they will receive a get certificate, but that's only once they have completed their civil divorce as well. So there's a joining of the two in order for them to receive their get certificate to be able to remarry. Thanks, Romina. Next slide. Okay, so we've spoken a bit about the logistics of how the get happens. The nuts and bolts of what you're going to be discussing with your clients is going to be more about the terms of settlement, similarly to what we're discussing with all of our clients, whether they're Hindu, atheist, whatever their religion. We need to think about financial terms of settlement, and we need to be thinking about children's arrangements. In this particular realm, we draw on the tractate of the Talmud called Ketubot, which is going to discuss in more detail the terms of settlement. It reminds me, when I'm thinking about what the terms of settlement look like for Jewish people, I would say that it's similar to the continental kind of contracts that are set out at the beginning of the marriage. So the ketubah is actually read out at the marriage ceremony, and it's just similar to the sort of French communauté réduite aux acquêts. It just reminds me of that, where you're thinking about provenance, you're thinking about assets acquired during the marriage, and also, unfortunately, perhaps liabilities acquired during the marriage. A settlement that is kind of within the realm of Jewish law reminds me of a Schedule 1 order, where the route of financial distribution flows towards the well-being of the children. You might have mum living with kids, she stays in the family home until they're no longer minors, and then that home is sold. So it kind of just reminds me of the focus being, well, how are the kids going to be cared for during the time of their minority? Assets will stay in the name of the person who legally owns them. That can become complicated if I'm mum and I have a house but I'm not working and I remortgage it and it goes under dad's name because he can have the mortgage, then that will be a query. But those are one of the nuts and bolts of what people would discuss during their settlement discussions. I found some were maintenance rich, some settlements, and perhaps asset poor, but it doesn't always look like that. And I think it's really important. I'm going to re-mention this when I'm going through my slide on tips to mediators. Mediated settlements trump all settlement principles in Jewish law. And I reconfirmed this with a judge that I spoke to on Tuesday, which is they would rather that we are going to be mediating settlements and that people can come to the Basin with their settlement decided and agreed. And whatever that looks like, if the clients themselves, if the participants themselves are comfortable with that, then that is totally acceptable. You might have clients who are halachically minded, that's minded more to frame their settlement within Jewish law, and others who are civil law minded. And you might have that husband is one and wife is other. So it's just something to be aware of when you're dealing with Jewish clients. Romina, next slide, please. I don't know how I'm doing for time. How am I doing for time? I think I'm okay. I'm whizzing. Okay. You are going to, so the importance, I've just written here, things you might encounter. The importance of encouraging clients to apply for their get early is a really important one. You can actually avoid using the get as leverage, getting it intertwined with financial discussions or children discussions by doing the get at the outset. As long as they're living in a separate home, they really can do the get as soon as possible. The benefit of that is that they have a sort of spiritual divorce without quagmiring it into all of their other arrangements. You might also find different levels of religious observance between clients. I've come across clients where they were very observant, one has become less observant, or they're not observant, but one is really, the get is a really important thing for one, but not so much for the other. So it's about balancing their needs in that respect. you won't necessarily find less observant Jews as knowledgeable about the get, and they might need your help in just giving them some information about an Orthodox court of law and encouraging them to move forward, and especially encouraging them to do an Orthodox get, which is going to be accepted in all parts of the world and by all people on the spectrum. The get's going to mean something different for each person at that time. I have had only culturally religious Jews who don't really care about it, but really care about the get. Perhaps they've heard about the politically heated side of it, and it's really important. And others don't really want to think about it. It's not important to them. I think it's important to remind your clients, or to think through with your clients, about what it might mean in the future for them. I've mentioned this 5 minutes ago. They may not be religious now. They may not really think that they're going to want to marry again or marry in a religious realm. But if they meet someone who's a bit more traditional, they are going to need that get in the future. So it's worth thinking about. I've mentioned it before, use of the get as leverage. Encourage clients to apply as soon as possible. If they don't want to do that, if they do want to leave the get till the end, then you can make sure it's written into your summary, your confidential mediation summary, either as an undertaking or under the 2002 Divorce from Religious Marriages Act. So you've got a couple of ways to hook it into their civil divorce if needed. Thanks, Romina. Next slide. Tips for the mediator. I'm repeating some of the principles that I've already mentioned to you, reminding you a mediated agreement trumps all other principles in Jewish law, which means if you can get your clients to settle their finances, settle their children's arrangements in the way that meets their needs and suits them, particularly and uniquely for their situation, that will be acceptable when they go to a Jewish court of law. Knowledge, mentioning the get at an early stage, not just mentioning the get, but encouraging clients to do the get. Guiding clients, as I've mentioned, specifically to a court of law where the get that they get is going to be acceptable throughout the Jewish world. And just being aware of disparity of financial knowledge, which I think I've seen in my Jewish clients and my non-Jewish clients. Often I'll have, and I'm sure you've seen this, clients for whom one is, absolutely savvy with spreadsheets and finances and financial products, and the other really needs bringing up, really needs helping so that we can make this an even playing field when we're talking and negotiating about settlement. Next slide, please, Romina. Okay, considering supporting figures. So in the Jewish world, there are people who are people of authority, people of safety, and people who clients might trust. And you can draw on these as resources to help clients. They might be rabbis, they might be rebbetzins, they might be, and we have quite a lot of in-community mediators who support clients. And I find these people invaluable to help your clients either navigate things outside the room or bring them in the room, a little bit like we would bring solicitors into the room to support their clients. So these people can also just be people in the community who your client feels that little bit more safe and secure with. I have found those to be really useful resources. I think we need to just touch here on the importance of helping your client separate the get from the issues that they need to do. The get has been a very highly politicized and criticized element, should we say, of Jewish divorce. And that is a discussion in itself, but we need to help our clients sort out the issues which they need to sort out for both their civil divorce, but also their life. They need to sort through their finances and they need to sort through their children's arrangements. So we need to somehow help them recognize that the get's vital, but it's not intrinsically sort of intertwined with those things. And my last one is just encourage clients to have their agreement to affect their get process written into their mediation summary so that it can be part of their consent order if they have not already done their get. Next slide. I think I'm done. Is that my slides? I've put here a glossary, but I'm not going to waste time on it. It's there if anybody wants to ask questions afterwards. Romina, moving on.
Yes, thank you so much, Deborah. Over to you, Sarah.
Thank you, Dora. That was very, very interesting and insightful. Similarly, there are considerations for Muslim families that need to be taken into account by lawyers and mediators alike when dealing with family law matters. So, Sharia law is often misunderstood. There are lots of misconceptions about it. But Sharia law is not just one body of text or laws that are set out. It is a way of life for Muslims, and it ranges all the way from telling Muslims how to dress, what to eat, to how to conduct themselves. And then you've got the real kind of legal aspect. So, what makes something a crime and how should it be punished? To make it very complicated, within Sharia law and within Islam itself, there are two kind of main sects, which I'm sure many of you have heard of, Sunni and Shia. And within those sects of Islam, there are schools of thought. So some people dedicate their lives as religious leaders, as scholars, learning and interpreting it very particularly how their sect and their kind of group interprets it and understands a particular piece of Islamic law. So something that I, as a Sharia lawyer, find quite interesting is some of my clients, and for mediators, they may ask this as well, will say, well, what about, for me, the Maliki school of thought is the one that I follow. So what does a Maliki leader say specifically about this action that I want to take, this financial separation, this divorce that I want to issue? So it's important to kind of have that in the back of your mind, just in case for some clients, as Devorah said, there's a very wide spectrum in terms of religious following, and some will be Muslim or identify as Muslim, but it's not that important to them. And for others, they will be very, very particular about the type of rule that they want to follow and interpretation. So Sharia law comes from the Quran, it comes from the teachings of Prophet Muhammad, peace be upon him, and it comes from interpretations by all of these religious leaders. As I've put on this slide, there are 3.8 million Muslims in England and Wales, and this was in 2021 and is continuing to grow. And as a family lawyer, what I've found is this is a really rapidly growing area. And I don't know if it's because there is kind of a reduction of the taboo within the community. Younger people are now, second generation immigrants, third generation immigrants who have been brought up with a more westernized culture are getting married and are divorcing. And they're more open to having these conversations and to coming to lawyers and mediators and wanting that third party intervention. Ramin, if we can have the next slide, thank you. So the recognition of Sharia law in England and Wales is really important. And I'm trying not to give a kind of very boring law kind of presentation here, but I think it's important to understand why for some clients, this can really change their position. So under our legal system, we follow what we call the Lex Loci celebrations principle. And this means if you have a marriage that takes place overseas, and it complies with the customs and practices and the legalities required to be valid in that jurisdiction, it will be in England and Wales. So we have a destination wedding in Jamaica. As long as the government in Jamaica says this is a legal marriage, then there's no way, there's not even a method for you to register that in England because you're already married. You have a valid marriage recognized in that country, it's recognized here. Where Islamic marriages add that extra complexity, some countries build Sharia law and build Islamic law into their civil law. So countries like Egypt, Pakistan, Iraq, for example, if you have an Islamic marriage in that jurisdiction, and again, it's recognized under that jurisdiction to be legal and valid, then it's recognized in England and Wales. Many of my clients won't know this. So where kind of the majority of the complexity comes around is many will come and say to me, I had a marriage, it took place abroad, but I never registered it in England, so surely I'm not married. And unfortunately, that's not the case. Again, many Muslims will have an Islamic marriage in England and Wales only. And because these Islamic marriages are not kind of governed by one particular body or one particular board. The advice that they're given by the imam or the religious leader can make it really kind of vague, and therefore they may be told something that's incorrect or misinterpreted and think that a Islamic marriage in England has meant that they are married, which unfortunately, again, may not be the case. So this can make a really big difference in terms of where they stand legally, and it can make a really big difference in terms of what advice they need to seek from either a mediator or a lawyer in terms of the guidance through those discussions. So in terms of marriage in Islam, these marriages, as I've said, can be conducted by anybody. It's usually an imam, a sheikh, a mufti, so a religious leader, but it can be anyone. It can be somebody's father or uncle or somebody in the community. So again, that legal advice about the validity of their contract and the validity of their position is not always sought out and given. During these processes, the bride should be asked for her consent 3 times. She's accompanied by a wali, a guardian, to make sure that she enters into this under free will. 2 witnesses are required. And the most important thing for the majority of Muslims, and where a lot of mediation is then required, surrounds the meher. So meher is often translated as dowry, but it's not really quite the same thing. But a meher is essentially a gift from the husband to the wife. And it's his way of showing, I am dedicated to this marriage. I'm dedicated to making it work. I'm dedicated to you, and I'm dedicated to entering into this contract. Now, this can be anything. It ranges from money to property to gold. And when it comes to gold, it can often be familial gold. So gold that's been passed down in the family for generations. And for many, many Muslims, this ends up being the real sticking point in divorce proceedings, because oftentimes the husband's family will want the gold returned. The wife's family will think, well, no, she should get to keep it. And we look at whether we apply Islamic law or civil law as to where we put that gold and what happens to it. Marina, if we can go to the next slide to look at divorce, please. Thank you. So in terms of divorce, many Muslims will say we want a Sharia-based financial arrangement. So we go back to that original slide when I talked about recognition of the marriage. Under Sharia law, under Islamic law, there is no such thing as matrimonial assets. So what a husband owns belongs to him. What a wife owns belongs to her. Anything jointly owned gets split equally unless there is evidence to deviate from that. Otherwise, it's pretty straightforward. There are very set rules about what happens to the meher itself. So if the husband is the one that requests the divorce, the wife gets to keep it, and anything that's not been paid must be paid to her. If the wife requests the divorce, she must return it. And if the divorce itself is because of an action by the husband and it's dissolved by the marriage itself by an Islamic body, then the wife gets to keep it. When we look at the marriage itself, we have to look at whether it's legally recognized or not, because if it is legally recognized in this jurisdiction, then we apply the law. And the law says we look at all of the assets, regardless of whose name is on it. We put them into a pot, and as a starting point, we look at equality. So can we split these equally, and can we meet everybody's needs through that equal share? Or do we need to depart from it? This is very, very different to a Sharia-based financial settlement or arrangement, which is why many Muslims will say, I need help. I want to find that area between the two where I can agree about the meher and we can make sure that the gold is returned properly, but also we want to make sure that we get a consent order and that it's passed through the courts and it's dealt with properly. So it's important for Muslims to get that advice at the outset before they get married. How can we look at this? Can we do it through a prenup? Do we need mediation at that point? Do you need to speak to religious leaders, to a mediator to talk about those arrangements? Or at the time of divorce, how can we bring in mediation to try and help settle this particular aspect? So just about the meher itself, for example, if that's the problem. So working alongside the Sharia Council, working alongside mediators can be a really, really useful tool for lawyers because it gives our clients that freedom to have those discussions without the confines of the law itself. So, Romina, I think it's kind of a really good time for us to have a discussion about all of this.
Perfect. I'm just going to stop sharing so that hopefully I can see some of the wonderful questions. Thank you, Sarah. Thank you, Devora. That was so interesting. And I'm sure lots of people found it extremely valuable. Let's have a look at some of the questions that have come through. I don't know if I'm able to see them all. Can you guys pick up some of the questions?
Yeah, I can see a couple. Can you see, Sarah? Can you see questions?
Yes.
Few questions I can see.
Oh,
One is,
sorry,
can you see that?
from someone, you said that the husband instructs the judge to write the get. So this is to you, Devora. Can the wife do that? Are their roles equal in decisions in the get?
It's two questions, isn't it? The first part is the husband doesn't instruct the judge, the husband instructs a scribe. Remember, the judge is just there to facilitate it. So he doesn't actively write the get, but a scribe would write the get. So I just thought I'd just make that definition. The wife does not instruct the scribe to write, and the husband does not receive. So the flow of that is that the husband instructs the scribe, and then the wife receives the get. The second, so that's the answer to question one. And the second one was, are their roles equal in decisions in the get? And Eileen, I'm kind of assuming you mean the part where I was speaking about settlement. And then I would say, yes, their roles are equal. They're discussing their settlement, similarly to how any clients would be discussing how they're going to come to an agreement for their divorce.
Thank you. Another question is to both of you. How do you know which marriages will be recognised and which won't?
I think that was
I'm
for...
happy to take this from a legal perspective. So it really depends on what we have before us. If it's a marriage that's taken place abroad, oftentimes we will seek advice from a lawyer in that jurisdiction to be able to clarify how it took place, whether it's recognised there. Some jurisdictions it's easier to tell than others. So, for example, in Pakistan, as of around about 2003, all marriages are now registered with the union council, the local council. As long as it's got that seal, the likelihood is that it is recognised. Now, even as lawyers, it's not for us to 100% say that. It's for the courts of England and Wales to then say, yes, under our jurisdiction, we will recognise this marriage, and therefore you can apply for a divorce here, for example.
Thank you, Sarah. Devora, what happens where one party does not consent to the get?
Yeah, it's an interesting question. And in my experience, it's both men who might not want to give and women who might not want to receive. And what I would say is, what happens in the legal sense is that as mediators, we try and encourage the giving and receiving of the get to be put into their mediation summary as an undertaking, and it can then be intertwined into the consent order, and then it becomes something which has hooked itself into the legal system, and it has more kind of clout, so that if one party wasn't going to agree to the get, there would be legal consequences for that decision. So that's number one. Number two is, as I mentioned, asking the judge to not proclaim or to issue the final order of divorce until such time that the get has been given and received. So that first aspect is about kind of linking it as much as possible into the civil legal system. There is a second line of fire, so to speak, which is within the Jewish community. Now, that can mean a lot to some people, and it can be not as impactful for other people. If somebody is a religious Jew living within the fabric of a religious community, social pressure is huge, not shopping at their shop, not allowing them to go into your synagogue, not giving them the honors that might happen to somebody in their synagogue. So social pressure, commercial pressure, and religious pressure We also within our communities have informal mediators who will really apply pressure and try and mediate what is needed so that they will re-engage with the GET process. In Israel, they have certain legal structures that exist, which we don't have here in England, but they have other structures. So, for example, they would potentially be able to not allow someone to leave the country until they've given a GET. So there's quite serious pressure put on somebody legally if they are refusing to give or receive the GET.
Okay. Thank you. This one's to Sarah from Daniel. I have clients who got married in Pakistan. They applied for a divorce here. Am I correct in saying that English laws apply when it comes to the division of assets? Sarah.
So I can't speak to your clients in particular, but looking at it generally, if you apply for a divorce in England and Wales and it is being dealt with under our jurisdiction, then the laws that apply in this country apply to that divorce and the separation of those assets. Essentially, there are some nuances to this, and it depends on if there is a divorce also ongoing in another jurisdiction at the same time, whether that one has concluded. Sometimes we can get into these really complex proceedings where we're arguing about which jurisdiction it's best to deal with these matters. But generally speaking, yes. And this is whereby a lot of clients will then say, well, look, I need help, as I was saying before, because they may want a Sharia-based financial arrangement, but that can be so far kind of removed from the way that our legal system deals with the finances. And therefore, it's looking at how we can balance those out. A consent order, no matter how many lawyers have signed to it and how much the clients want this and have consented to it, still needs to be passed by a judge and still needs to be approved. And therefore, clients can say, well, we want this Sharia-based agreement and we're just going to leave with what we've got, but we want this in an order of the court. And a court could say, no, this arrangement doesn't fall within the principles of how the finances need to be split in our jurisdiction. So it's important to get that balance of legal advice and religious guidance, if clients want that, to try and intertwine the two.
Great, thank you, Sarah. This question, I think, is a good one for you both to try and answer. So Jane says, I'm struck by the sense that both of these systems still treat women as lesser beings. Do either of you have that sense?
Do you want me to go first, Sarah, or do you want to go first?
Feel free. Very welcome to go first.
Yeah, it's a highly political topic, and I think it's probably one that we won't manage to complete or really dig deep into in the next 20 minutes. And we could definitely spend 20 minutes going into the ins and outs around it. The question before that was, can a wife initiate a GET or just the husband? And that is a one-word answer, which is a wife can initiate the GET. And the reason I mention that, Jane, in conjunction with your question, is because a wife can initiate the GET and a wife can refuse the GET. I think maybe what you're saying, and you can write in the question and answer if I've misunderstood, is your perception of the flow of the man is the giver and the woman is the receiver makes her lesser. And I guess that's a matter of perception. I don't feel that the fact that she's the person who receives it and stands up and holds it and keeps it makes her a lesser human. I would say they're different roles. So if she wasn't able to apply for the GET, then I might sort of feel like, wow, that's really, she doesn't have the rights, but she does have the right to apply for it. And she has the right to sort of push it, so to speak. So I'm trying to sort of work out where your lesser beings question is coming from. You might want to clarify it. Do I have, maybe Sarah, you want to continue and I'll think about that in a more general sense? What's your
Sure.
thinking?
No, and I completely agree. I mean, from an Islamic perspective, the woman, the bride, she is given a gift at the outset, a financial gift that she will consent to, that has to be provided to her, so not to her family. And some countries, some Islamic countries, have actually criminalized that act where it's given to the family itself. So it has to be given to the wife. And if the husband is the one who's choosing to give the talaq, to give the divorce itself, then she gets to keep that. And as I've said, if it's not been provided to her, and let's say she's asked for $100,000, which I've come across before and it's not uncommon, and he's only paid 50, then he must provide the rest to her. So women have that protection and they have that at the outset. Women can also, although they can't give a talaq themselves, generally speaking, at the time that the marriage contract is entered into, they can say, I want power of talaq. So I want power to request a divorce. And they can have that if the husband agrees, because both parties have to agree to it, that can be drafted into it. Now, if the wife doesn't have that, she can apply for what we call a khulla, which is where the divorce is at her request, but an Islamic body or a religious leader will divorce the parties. The husband is essentially still consented to it, but it's not come from him directly. Now, if he refuses, it doesn't mean that the wife has got no kind of avenue to go down whatsoever. She can go through the process of a fasakh. So that's where the marriage is dissolved. And the wife can say, he's refusing to give me talaq, he's refusing to divorce me. He's refusing to consent to my request for a divorce through the process of a khulla, but I no longer want to be married to him because he is not treating me right. He is not providing for me financially. He's not looking after the children. He is not religious anymore. It's a whole bunch of reasons. And again, an Islamic body can dissolve the marriage. So, Jane, feel free to kind of type out more if there is a particular query that you have around this. But I think there is a lot of misconceptions about that. And, you know, many Muslim clients will come to me and say, oh, I had no idea that I could ask for power of talaq, and I had no idea I could ask for a cleaner 4 times a week. You can put whatever provisions you want in your marital contract, and the bride has as much of a say as the groom does at that time.
Okay, thank you very much. Devorah, back to you. Beverly is thanking you for a very clear presentation, and could she see the glossary again? I'll answer that bit, Beverly, which is all of these sessions are recorded and then accessible, so you can obviously take your time to go through all of the slides and take the information that you need from them. She goes on to say, and I have had a husband refuse a wife a get. Does this mean one does not feel divorced, and is it fundamentally a problem in the future?
Yeah, clear answer to that. Yes. I mean, it depends on the religious level of the clients. Like I said, some clients just don't care. They don't really care about the get and they don't want to engage with the get. They are then not divorced according to Jewish law. And it can be a problem in the future for a few reasons. One is because one of them might want to remarry. When I was working at the London Beth Din, I had a man who actually had refused to engage with the get process 30 years before. And he had a lady friend now who he wanted to marry, and she wanted to marry in a more traditional synagogue. And we had to trace this man's ex-wife, who was in Ireland somewhere, and sort of was like, well, no thanks, I'm not going to come. Should I, I'm coming to London in July for a Michael Bublé concert. Maybe I'll come, maybe I'll think about it then. But in the end, we really couldn't get her to come. So the consequences of not doing it now can be really quite dire for them in the future. And it is worth just gently engaging people with it and just letting them know that they might look back and wish they'd done it now. So I would also add that non-religious clients who I have sent to the London Beth Din, the Federation Beth Din, are received warmly, and it is a less intimidating process than they realise. The Bate Din, the Jewish courts of law, make sure that people have support, they can have family, they can have friends with them if they need. They make sure that for women coming in, there's always another woman in the room so that they're not feeling intimidated. So they try and make it as palatable a process as it can be. It is a foreign process for a lot of people. If they've grown up very assimilated and they don't really know much about it, it can be a little bit intimidating, but it is a good idea to try and help your clients engage with the process if possible.
I think what was interesting that I took listening to you both, but in particular in this topic, is the idea is to have that information available so that you can make clients aware and say, look, maybe today you feel like this, but in the future, this could be something that comes back and you need to obviously circle back round. So I found that very helpful for me.
Romina, yeah, that's really helpful. The other thing I would say, Beverly, is at my time working in the Based-In, so at the London Beth-In, I found 99.9% of the people who were refusing to engage with the get process, whether it was the husband or the wife, it was because they were upset about an aspect of the divorce discussions that were happening that were more normal discussions. So, you might get a husband coming to me and saying, I'm not walking into the Based-In until I get to see my children. So really the issue isn't the get there. The issue is that this is a father who wants to see his children. And in the same way, I had women saying, I will not accept the get until he pays off the debt he's let me in, or until I get more maintenance, or until etc. So I think one of the important things as a mediator to think about is, like I said in my slides, trying to help clients separate the get from the actual issues that you need to help them work through. In my experience, once those issues were worked through, once they had a financial settlement that they both felt they could kind of breathe with and survive with, and once they had arrangements for their children that felt right for each of them, it's not always a balance we manage, but we try, then the get became less of an issue because they were kind of ready, if that makes sense. So in that sense, maybe the get became a bit more like the final order, where yes, we've arranged our finances, yes, we've arranged our children's issues, and we feel ready to kind of close the marriage.
Thank you. This is from an anonymous. How would you deal with going through the religious process when it is a person who is abusive? I know in mediation we have shuttle. Is there something similar with these? I've had clients who've been divorced legally, but are unable to get divorced in their place of worship and are shunned by the community for not wanting to see the other party face to face and have had to leave their community. It's a really good point.
Yeah.
Sarah, do you want to come in on that one first?
Sure. It's a really sensitive and a really sad topic when communities can be involved in a negative way, but they can always have a positive impact also. I work very, very closely with a lot of the Sharia councils in England and Wales, and I am a really big advocate for bridging those gaps for clients, for lawyers, for mediators, for everyone really. Us as a population, we're ever growing and multicultural. And I mean, firstly, dealing with somebody that's abusive, there are safeguards in place to deal with that, whether from a legal or a mediation perspective. So, similarly to how you have shuttle mediation, the Sharia Council will also deal with it separately. Parties don't need to see each other, they can be kept in separate rooms and have separate contact from each other. In terms of unable to be divorced in their place of worship, I can't speak to this particularly. I can't say that I've ever come across it. I understand that there is a bit of a nuanced taboo about it where clients have said to me, well, I'm worried about what the community will say, and I'm worried about this, and I'm worried about that. But what I do is I personally link them up to somebody who I think that they will feel comfortable talking to about that. So caseworkers at the Sharia Council who are women, for example. A lot of my Muslim women clients who want the Islamic side of matters to be dealt with will feel much more supported and comfortable talking to another woman. And that's fine. I can do that for them. Same with male clients, many of them will say, well, I've been through an abusive marriage and I don't want to see my wife and I want to deal with this quite privately. And they can be offered that privacy through the use of an Islamic body, an imam, the Sharia Council, anybody I feel that they will work really well with to try and achieve what they want. In terms of leaving the community, it's a really, really, again, sad situation when that happens. And having these types of discussions and having these types of webinars and, seminars and talking to each other within these communities helps bridge those gaps, and it helps lessen that taboo and make it something that it's okay to talk about. And I know the three of us talked about this the other day in terms of how we can deal with this and bringing people together and making sure that clients feel supported completely in terms of their religious and their legal needs. Devorah, do you feel the same? Is it something you've come across?
Yeah, it's a really important question. And while you were answering it, Sarah, I was relieved to hear that there's so many structures in the community, in the Muslim community, to help victims of abuse. I'd say intrinsically interwoven into the GET process is this idea, like you were saying, that they can give it to an intermediary. They don't have to see each other. They don't have to be in the same room. And there doesn't have to be this kind of often terrifying interface between clients. So I think in answer to that, both Islam and Judaism seem to have kind of toolkits put in place to help at least clients not have to interface with each other. I think in terms of domestic abuse, I spend a lot of time thinking about this, and not just with my Jewish clients, because somebody who is abusive is going to use all the tools that they can to continue to be abusive. So we look at people who continue financial abuse through maintenance, or whatever it is. They're going to take something and use it to be abusive. And somebody who takes the get and uses it to be abusive, it is another tool in their toolkit to try and delay. Or somebody who spends excessive funds on proceedings in court and and is abusing the court system in order to abuse their ex. So that there are these things that are happening, and we as communities need to stand up and stand against them. I mentioned a few of the ways that we would do that. I mean, we have had people in our community picketing outside somebody's house to put that pressure and to say, no, it's not acceptable, and this community does not accept abuse of the system to abuse another human being. So I'm trying to read that again and just make sure I've answered it. Have I answered that? Okay.
Yeah, you both have answered it extremely well, so thank you. I'm conscious of time, and the wonderful thing is that we've had so many questions. So I mean, I'm obviously choosing questions that I'm finding really interesting, but if there's ones that either one of you want to pick out in particular, please say. If not, I can keep going, and we will do our best to try and answer as many as we can. The next one.
Ramina, this one here,
Yeah,
sorry, it brings us to a nice kind of discussion that three of us had yesterday about cultural disparities and language. So, for the two of you as mediators, do you think that you have to be a Muslim or a Jew or of a particular background or culture to deal with these types of clients? Because from a legal perspective, you've got to have that knowledge and that expertise. But many of my colleagues will come to me for advice on that particular aspect, on the Sharia aspect, and they can deal with the rest of it. However, my Muslim clients, when they come to me for an initial consultation, firstly, if they want it in Arabic and I speak Arabic fluently, great. That's a huge kind of tick and a bonus for them. And secondly, a lot of them will sit down and say to me, "Are you Muslim?" It's kind of the first question they ask. And they want to know whether I am or I'm not, so that they can feel comfortable knowing that they don't have to explain small cultural nuances with me. When they say something like, "The marriage broke down because I moved in with my in-laws," they don't need to tell me anymore. I understand, it's fine, we don't need to go into it. Or when they need to say, the mahar is really important, that's fine, I understand, do we need to focus on it and bring that into the legal system and know how to deal with it? So from a legal perspective, I think it's important for that knowledge aspect for anything that is applied. But from a mediation perspective, what do you both think?
So as you know, we talked about it just the other day, and I think the most important thing as a mediator is that we have a good idea of our clients and what they're trying to achieve. And I do think as part of that, having some knowledge as to their cultural and religious beliefs, especially if they're talking about it in mediation, just helps guide those conversations. Now, do I think that if you've never come across it as a mediator, you therefore shouldn't, partake in the case? Absolutely not. Because let's remember, we're also thinking of examples where perhaps both of those parties are from the same religious background. They may not be. And so actually as a mediator, our role is to remain impartial at all times. We're there to help them, guide them, provide that support if they need it, but we're not there to have an opinion on it. So I think it's good that we know about it and we're aware. And I think that all mediators, regardless of your cultural, religious backgrounds. You know, I get the same thing. People assume that I'm Muslim because of my name. And I then have to explain, no, my husband is Muslim. And I sort of explain that we are mixed race, totally different religions. And I think they do feel instantly at ease. So there's a lot to it. And I just think the wonderful thing about mediation is that it should be accessible to everyone. And as a mediator, therefore means that we should be trying to help and support everyone that's in the process.
Can I add one thing?
Of course.
You both suddenly looked frozen. So the idea of needing a mediator within a community can be really important. I mentioned yesterday when we were chatting that occasionally I've sent people actually totally not out of the community because I felt they needed somebody who was not sort of within the fabric of the community to help them. So Sarah, I agree with you. I think people feel relieved when they know I know about various aspects of Jewish life and tradition that are important to them culturally, if not religiously. But I've also felt sometimes like it's helpful to have somebody who isn't always in the community. So I don't think that these clients should be only sent to Muslim or Jewish mediators. I do think just like it's a responsibility for all of us as mediators to continue to educate ourselves about all the things that we're going to need to know as mediators. This is one of them. This is one of them. So if you're not Jewish and you're not Muslim, or for example, for me, it's my responsibility to know a little bit more about Hindu culture that might impact on families, or Muslim culture, or it's part of my training as a mediator, just like I had to, as a non-lawyer mediator, up my game and understand law. I need to up my game and understand the cultural nuances that somebody in a particular religion is going to feel. So I think that's just part of our responsibility as mediators, is to continue our education and deepen our knowledge.
Absolutely. Were there any other questions in particular that either of you wanted to pick out, or shall I just keep going through?
Which media? I'm looking at the questions.
Okay, because I've got, thank you, this is Marianne again. Thank you to both Sarah and Devorah for your presentations. Can you confirm that mediation makes a difference to women's rights in family mediation?
Can you confirm that mediation makes a difference to women's rights?
In family mediation? That's an interesting one. I think perhaps it might need a slight rephrasing, because I assume you're wanting us to speak in terms of how women, if women feel that their rights are protected in the family mediation process. I mean, in terms of the mediator, we are constantly assessing if mediation is suitable for both participants. And as part of that, we are assessing whether they're able to have a voice, whether they feel as comfortable as they can in terms of expressing their viewpoints. You know, do I think that mediation gives additional women's rights? Not particularly. I don't know if either of you feel different. Devorah, Sarah, what are you thinking on that question?
Shall I answer first, Sarah?
Feel free.
I think what I would say is, as a mediator, it's my job to assess the appropriateness of mediation for everybody in the room, for women, for men. Are they able, do they have capacity to have these discussions? Do they feel safe in these discussions? And do they have the kind of ability to really effect a safe agreement together? And I think maybe I'm not answering the question, but if I felt that anyone's rights or anyone's ability or capacity was diminished by being in mediation, then I would send them to the safety of solicitor-led discussions, because this would not be the right realm for them. So I'm not sure what women's rights particularly means, because my job is to assess, is mediation the correct route for the discussions that these people need to have? I think, unless I've misunderstood it. Sorry,
Yeah.
do you have any wisdom to share? Yeah.
No, I completely agree. There are circumstances in which we need to be involved as lawyers. We need to make sure that whether it's a woman or even a man, they're protected by virtue of a, restraining order or similar, an injunctive relief through the courts, if there is that need for it. Otherwise, the rights for women, for men, for both, come from the law and the legal system. And if it's from a religious aspect, then it comes from our bodies of text and it comes from our religious laws. So mediation can be a really useful tool to highlight those. It can give women, for example, that kind of podium to have their voice heard and to make their views known to the other side. And if they want to go through the process of mediation to put forward their views without need for lawyers, then they can do so. You know, mediation is something that in Islam has always been there, and there is a need for mediation and a almost expectation for mediation to take place. And therefore it's ingrained in our culture, and it's ingrained for Muslims to use religious leaders and to use members of the community, and to use, now it's more common, third-party mediators and independent mediators to help facilitate those discussions. So women's rights are they affected? I mean, they're not changed by mediation, but they're certainly given that podium and that stage to have their voice heard.
Excellent. And I would say that initial meeting, when we first have our clients attend what we call a MIAM, that initial meeting is where we would signpost our clients if we feel that something that they're disclosing needs that additional support or exploration. That's really where we would not only be assessing, can they actually continue with the process, but here are some groups, you know, charities that can support various topics that are brought up. I'm conscious of time, so I think there are still some unanswered questions, but we are obviously now at the end of the session. So I want to thank everybody. I want to thank Sarah and Devora for a fantastic and informative presentation, and for all of your questions. Details of all of us are on the Family Mediation Council website, so you can of course pick our brains if you need to, and this recording will be uploaded as well. So I want to thank you all.
Thanks, Romina. Thanks, Sarah.
Thank you.
Thank you.